Real happy to talk to my next guest on the Sports Card Shop guest line. He was here back in August, episode 246 to be exact, and we spoke specifically about one case. And I promised him when we had him back, we would cover a little more ground, and that's what we're going to do today. But without further ado, welcome back, Paul Lesko, the hobby lawyer, as he is such known. And welcome back, Paul.
Oh, thanks for having me back on.
Wow, glad you came back. Last time, like I said, was August earlier this year. We really focused heavily on that Fanatics versus Panini or Panini versus Fanatics case. I will start there, just kind of the update, if there's anything to update since August. What say you?
Yeah, sure. So this is the case where, and it's actually multiple cases. It's not just one case. It's when you have big litigation like this, there's just lawsuits going back and forth. So the lawsuit initially started with Panini suing Fanatics, alleging that Fanatics had stolen 35 of their employees improperly. Then Fanatics later filed, or Panini then filed another lawsuit against Fanatics alleging antitrust violations, that Fanatics was creating an illegal monopoly in the hobby, to which Fanatics then fired back a lawsuit saying that there was unfair competition between it and Panini, where Panini had entered allegedly into some types of conversations about maybe assigning over all of their exclusive licenses to Fanatics. But Fanatics was saying that this was actually, Panini wasn't doing this in good faith. We Fanatics put a lot of money into this negotiations, and it was all a waste of time, and we lost money and we lost time and everything else. So it's big, huge lawsuits. And then you also had a couple, what I would call like follower on lawsuits, where the WWE and the NFL Players Association, they had exclusives with Panini. And they alleged that Panini was in breach and that they were going to take the exclusive back and give the exclusive back to, or not back, but give the exclusive to Fanatics. So, last time we talked, we had all those, missiles of lawsuits all flying at each other, all, somewhat related. And since then, we have had actually a little bit of activity, mainly in the side actions, the Panini versus WWE and the Panini versus the NFLPA. In both those actions, as much as we can tell, it looks like Panini did better than the WWE and then the NFLPA. Because in the WWE lawsuit, the WWE wanted the immediate end of the exclusive contract with Panini, and they wanted money. They wanted Panini to pay money. So they basically wanted Panini's done, immediately stop making cards. Fanatics will start making stuff. So that lawsuit went on for a little bit. There were a couple emergency hearings that were set and scheduled to go there that the WWE wanted the judge to say, we win now. And in there, the judge said, hey, right now, I don't see enough what's called irreparable harm happening, because Panini says that they can still make cards. They're still ready to make cards. And you're not alleging that the card quality that they're making is bad. You're just basically alleging that this contract should be over for whatever reason. So that's something we'll address at the end of the lawsuit. But as for now, I will let that keep going. So that lawsuit settled, and we don't know the terms of it. So we're trying to figure out who won. And there have been some indicators that maybe Panini won this, because while we haven't seen too much more WWE product from Panini, I believe it was this weekend, we saw that Al Snow was signing some cards, some Panini cards. He put out, I don't know if it was him or somebody who took a picture and showed it. So that seems to say to me, although we don't know what happened, but if the WWE was asking to shut down Panini and make no future cards, and then the case settled confidentially, but now we're seeing Al Snow signing some cards that will be released, it seems to say to me that at a minimum, Panini may have won, because maybe the status quo, at least for some time frame, is still going to continue. Similarly, in the NFLPA action, that one's in an arbitration. So we really don't know what's happening there. It's in secret. It's not in federal court where you can typically see everything that's happening. But there, the order, there was an order that was leaked that gave us two pieces of information. Number one, that judge was going to do the same thing as the WWE judge and say, hey, I'm not shutting down this product line while the lawsuit's ongoing. So Panini, you can keep making NFLPA cards. But then also in that order, the arbitrator / judge mentioned that the parties agreed that while this lawsuit was going to continue, that Panini could continue to make NFLPA cards. So those matters. So the NFLPA matter is still going on. It's in secret. We don't know ultimately who's going to win that one. WWE matter, we think Panini may have won that one because they're still making cards. And, and those are interesting things to watch because there are allegations in the Fanatics and Panini lawsuits that those lawsuits are really focusing on those exclusives. So as these littler actions are decided, and so far it looks like Panini's been in the lead of those, they may ultimately influence the antitrust actions or the other actions too. And those actions, the Fanatics and Panini actions, those are moving slower. Right now, we're basically in what's called the motion to dismiss stage, where both sides are saying, "Hey, these lawsuits are, worthless. You should get rid of them. You need to look at them." And we probably won't get rulings from the courts in those until March, April, May. They don't move fast. The only real thing that happened is Panini in the antitrust action sued Fanatics in Florida. And Fanatics got that case moved to New York, where its action is and where all the leagues are. So it kind of makes more sense. So you could call that a victory for Fanatics, but it's really, nowadays it really doesn't matter which judge looks at it. All judges are basically the same. They're all fairly decent. So it's it's a big win for Fanatics, but it's not really, doesn't affect the case. And we'll just have to wait until later this year to see, or later next year to see, who's actually going to come out on top of those cases.
So kind of to paraphrase, you said it a lot better than I could,
I wouldn't say better, I'd say longer.
No, I think better too, both. Panini's kind of won a few of the smaller battles, but in the bigger war, which is the Fanatics Panini litigation. Two-pronged question, Paul. Number one, do those little victories, if we want to call them that, and I think you touched on this a little bit in your answer, do they factor in the main litigation or not necessarily? They're kind of separate. And then my second question is, like you said, this thing could drag on. They're in the motion to dismiss phase. The Panini's license is really only to 2026. Is there a chance that this litigation even lasts till that year, and Fanatics just gets the licensing just because Panini's time's up anyway, and then there's no need for a court ruling? Is that something is that Panini what they're trying to do just so they can make cards for those 2 years, if you will?
Yeah, and that's, I'll start with that second part first, because yes, it's very likely actually that the litigation will outlast the licenses. So you have the litigation, at least the WWE and the NFLPA litigation was definitely there to try to end those licenses. And the judges, it's, while every judge is different, these two judges seem to say, hey, we're not going to end these early. You have to go through the entire litigation to get there. And excuse me, typically, litigation, on the fast track nowadays is 18 months from beginning to end. And that's fast, which is sad. So, and that's for simpler actions. So you're really looking at, maybe like 18 months from now, that's going to take you into mid 2025. And then you're not even, depending on who wins, there could be appeals. And then when you were talking about the antitrust action, that's complex. There are some courts that when you have an antitrust action, they start you at 2 years. That's the shortest it will take to get to the end of the case. So while, and I think depending on who you're looking at here, Panini may want to draw out some of these actions to actually get the full amount of their licenses. And then you get into some awkwardness, because what if Panini goes through the entire time frame and then ends, and then Fanatics comes in, but there's a lawsuit saying that maybe Fanatics licenses aren't right, so Panini or another party has to come in and get a license. I mean, it could be a huge mess, and that's why it's fun to watch these, because there's and to get to your first part, yes, these little pieces do affect it, because the antitrust action that Panini brought, the most important issues there for it are that Fanatics will have all the exclusive licenses, and Panini says that's bad. So, and they're also saying that bad things happened. That Fanatics did some bad things in order to try to get these licenses earlier, or in getting some of the licenses earlier. So you can see where, if in one of these actions, if the court would rule in one of the smaller actions, if the court would have ruled in WWE, say, that we found Fanatics somehow interfered with this action, well, then that looks good for Panini in the Fanatics action. But if we have in one of those actions, if it proceeded and Panini was found to be in breach of the contract because they didn't do something, well, then that's good for Fanatics, because it tends to say there's not much of a chance of an antitrust if Panini couldn't handle the contract. Well, we're saying that we could, and that's how the free market works. If the licensor is not happy with the licensee, they can shop their goods elsewhere. So yes, they are related. Unpredictably related, and that's what makes it's like a 3D chess game is really how it is right now. So it's just, for someone like me, it's just very fun to watch.
Yeah, no doubt. I know this is your thing, and you enjoy it. And you mentioned one last question, and then we'll move on to some other cases I know you want to talk about. Is there any way in 2026 that Fanatics can't start producing football and other cards that they do have the licensing for starting then? Is there any way they could be delayed in printing those, or is it a moot point? Like, if it gets to 2026, they have the legal right to start making them, and Panini doesn't? Is it as cut and dry as that?
The only way that Fanatics could be stopped from making these is if a court rules. So, and the action that you're looking at for that would be the antitrust action, and that's the one that takes the longest. So, I would think it's unlikely that action would resolve itself before Fanatics starts those licenses. So I think if you look at the timeline of how it's supposed to be with, Fanatics taking over in 2026 or whenever that is, I think those timelines are safe. The interesting question comes in, if Panini is able to prove its case, can they unwind that license or not? And judges normally don't like to unwind business things that are happening. They might just say, well, this is bad, we'll award money. And then, Fanatics, you have to pay Panini money or something. So that's a more likely result. But I don't think it's likely, if the court is going to look at ending a contract, I don't think it's likely to happen before Fanatics would take it over. And then the interesting part is, if a court says, okay, Fanatics, you've got too many licenses, you can't have them all, a court's not going to order the licensors to say, hey, Panini, you get it. If anything, it'll be okay. It's open to the free market. Anybody can step in, and anybody can do anything. So lots of questions. That's why this case is so fun. These cases are so fun to watch.
Yeah, and like you said, this thing's not going to end tomorrow. This thing is going to, they're, like you said, they're in just the motion to dismiss phase. So this thing's going to be at least a year, and most likely longer. As promised, Paul, I know, again, last time we were on in August, we really focused on what we just talked about, the Panini Fanatics lawsuits and the offshoots of that. But as you mentioned on that show, there are plenty of other litigation involved pertaining to the hobby. And I promise, next time I have you on, let's talk about some of those that kind of move your meter, pique your interest. So the floor is yours. Whatever you want to kind of bring up and kind of, set the stage or give your synopsis of what's involved and what's pertaining to the lawsuit.
Sure. And I think the easiest one to start with is my what I'm calling my case of 2023. It's my favorite case of 2023. And not only that, it's a case that started in 2023 and ended in 2023. But this is the what I'm calling the bangbros.cards case. This is a case where there was a website, bangbros.cards, that was making pornographic cards of Bang Bros adult film stars. And the cards, though, despite the subject matter being somewhat lurid, were using Panini's trademarks all over the place. You had Prism cards, you had, I mean, it was just rated rookie. You had everything. Every one of these cards was using, I mean, Panini's trademarks, and it was even to the point where I was confused as to, I mean, it really looked legitimately like, Panini's cards. And that's what trademark law is, and that's what this lawsuit was about. It was a trademark lawsuit because consumers could be confused as to who licensed this. And so Panini filed a lawsuit initially against Bang Bros, a parent company. I think it's called Sinestra. And come to find out, Sinestra, Bang Bros, wasn't making these cards. They were actually even infringing Bang Bros, if not the actresses that were on their IP rights also. So Panini went back, did some research, and they believed an individual named Ryan Carter out of California was the individual that was actually creating and producing these cards. So Panini filed a lawsuit against Ryan Carter as doing business as bangbros.cards. And the website got taken down. Mostly because at that point, Bang Bros got mad, and Bang Bros went to an arbitration type action to immediately get that website taken down, and they were successful in doing that. So Panini was suing Ryan Carter to stop him from making the cards, which they weren't being made anymore, at least, or weren't being sold on the internet. They may have been sold on eBay separately, but Ryan Carter never showed up in the lawsuit. So Panini just recently moved for a default judgment saying, hey, judge, here's our case. Here's all of our evidence. The other side didn't show up. We should win, and you should give us $616,000. The judge, I think 2 or 3 weeks ago, looked at the order, looked at all the evidence, and gave Panini almost all $616,000 in the default judgment. He deducted like $70 from the judgment because he noted that Panini didn't have a trademark registration for Kaboom. Panini tried to get a trademark registration for Kaboom, but was unable to successfully get that because there were some comic book stores that had Kaboom or Kaboom-like trademarks. So the judge did his homework. He looked at everything. He looked at every registration, deducted $70, but Panini ended up being a big winner. So they now have a piece of paper saying that Ryan Carter owes them $616,000 for his infringement. So there's multiple lessons in this lawsuit. One is, don't rip off somebody's IP rights. The other is, if you do get sued, show up to court and defend yourself, because the other side may very well get everything that they're asking for that. So that's my lawsuit of the year, and also simply because it was contained within a year. From January to December, it was started and wrapped up, even with Panini suing the wrong party initially.
That's what happens when you don't show up to court. You're going to most likely lose. Now, chances are, I don't know Ryan Carter. I'm assuming you don't know. This may be a gentleman in a basement just producing these. There's a good likelihood he doesn't have $600,000, even though what happens I always wondered about that just in general court cases. When someone loses a court decision and they're supposed to pay said amount and they don't have that to their name, what happens with that?
Yeah, this is where Panini has a court order saying you owe us this much money, so they can go trying to go to the debt collection process, try and get his paychecks, have money taken out of there. If they do try to enforce it against him, I imagine we'll see a future bankruptcy action. Carter will declare bankruptcy, And then it will be up to the bankruptcy judge to not only, make sure that that debt somehow gets somewhat paid, but any other debts that Carter may have also. So that's where you get the pennies on the dollar, potential pennies on the dollar payment here. It's a great $616,000 judgment. It's unlikely Panini will get $616,000. And in fact, there was another hobby case that happened just recently. It was only over about $200,000, but in the bankruptcy judge ordered the defendant to pay $1,000 a month until the full amount was paid. So here you could see, $1,000 a month for 600 months, 50-year payment type plan or something for Panini to get it. But sometimes when it comes to trademarks, really what you're trying to do as a corporation is get that win to show others that my trademarks have value. I was willing to get this money. And it really becomes that judgment just hanging on your refrigerator. It's really cool, but you're probably not going to get paid for it.
Can they garnish his future wages? In other words, he starts a new job, he's an employee. Can a judge or whoever makes that ruling say, almost like, like payments for child support? So much comes out of your check automatically and goes to the recipient, and obviously child support, it's usually the mother of the kids. Can something like that happen against Ryan Carter, where future employment, so much is coming out of his check and going to Panini, or not necessarily?
They could try to do that. It's never guaranteed, especially when it comes to like a business doing. I mean, in a case where it's a family, where there's kids involved, where there's an alimony involved, I think courts are more willing to garnish wages there. They still may be willing to, in this instance, try to garnish wages for that. But I think ultimately that would be determined by a bankruptcy judge. And and that's, a ways down the road. And really, how much does Panini want to spend, throwing good money or bad money after the good money to try to get this? So it wouldn't shock me. I've had similar actions like this, never that big. I mean, we once had a $35,000 default judgment against a copyright infringer. And, we just left the day with that. We enforced the client's IP. The client was happy that everything got shut down after that. And, basically we actually did that. We hung the order on our fridge in our office, and put a little A+ on there. And, that's the best thing you can do with it.
So now, obviously for Panini, it's a win because they don't want their brands associated with that kind of material. If there's stuff still on eBay, they can legally go to eBay and say, hey, we won this case. Those auctions have to be removed. We didn't. Those are our rated rookie logos. That is an unauthorized, copy. eBay would have to remove those auctions from its website, and then the other selling platforms as well.
Correct. And the reason that they have those warnings that are there that you have to notify eBay to take them down is because you're giving eBay a reasonable time period to do that so they don't get sued. That's why they get those. They're not taking it down out of the kindness of their heart or because there's a court order there. There's because there's some case law saying, hey, if the IP owner tells you eBay that there's infringement going on and you don't do anything within a reasonable time frame, they can sue you for infringement as well.
All right. And so but just to kind of put a bow tie on this one, Bang Brothers actually, they weren't responsible for the production. This was just a lone wolf, someone in their house or whatever, that decided to make these cards of these actresses and stars of that genre and use Panini sort of copyrights, rated rookies, kabooms, that sort of thing. And so Bang Brothers is are they involved? Are they suing, or this case is over?
They have not sued. I don't know if they would. I think it's, a dry well at this point. To the extent there probably was any money, Panini's first, and Panini will get it. They certainly won't get all $616,000. But I think it's more of Bang Bros can just be happy in the fact that they got the website shut down. So that shows again to them. And the most, when you look at a company, money's obviously nice, but also what's really important is to show that we have IP, we enforce the IP, and we win on our IP. That really helps in later lawsuits to show that you have strong IP. So regardless of if Panini gets any of this money, they can point to their rated rookie cards and say, hey, we've successfully litigated these cards and we've won a lot on these. And before we give up on this case, another reason I love this case so much is because the Bang Bros Cards actually changed rated rookie and they made it X-rated rookie. And I just thought that was so funny. And now, unfortunately, whenever I'm seeing like the new rated rookie cards for the NBA products coming up, I'm like, but first thing I think in my head is, oh, X-rated rookie, so he's kind of, at least in my mind, added this little, a little thing. Every time I see rated rookie now, I will think of the Bang Bros Cards case.
Now I got to put you on the hot seat, Paul. And I know you collect cards that's one of your things. You collect as cards pertaining to litigation. Is this any of these cards? Do you own any of these?
I do. So I went out and I bought a couple of them when the lawsuit actually was started, and that completely ruined my eBay searches. My eBay suggested searches after that were just horrible. But then also I received a anonymous package, which actually contained a box of cards of the Bang Bros Cards. So I had a funny tweet thread that I put together about opening these. And I took a picture of each one of the cards and I shared that so people can get a laugh. But also, forgetting that my phone syncs to our family's photo server and our screensaver of our TV pops stuff up. So somehow I accidentally, when I did this, put these Bang Bro cards on our family screensavers that popped up. So yeah. So long story short, yes, I do own some of these. They are very fun cards. They are not displayed on my desk right now, as you can imagine.
That's funny. All right. Again, like I said, open floor. What else do you want to let people know about that is interesting to you and obviously interesting to the hobby and hobby involved?
Sure. So another action that I'm like watching and I like a lot is the Lorcana case. So Lorcana is a trading card game that was released this year. Its main licensee is Disney, and it's been a fun product to actually watch. When it was released, there was insufficient product that was out there. So you had high prices, people were upset. And now Ravensburger, who's the company that's making these Disney products, has flooded the market with these cards. So now the prices are dropping. So it's really fun, at least from that standpoint, just to watch people who are newly into collecting cards, newly into trading card games, how they're getting basically a good master's class and, limited supply, overproduced supply, potential counterfeit cards that are out there. People are always worrying about, hey, is this card an error card because it's got a nick in the corner? It's like, no, that's just a damaged card. So it's fun to watch that way. But before the cards were released, Upper Deck actually sued Ravensburger and the creator of the game, one of the creators of the game, Ryan Miller, saying that Ryan Miller used to work for Upper Deck as a consultant. And they were working on an Upper Deck trading card game called Rush of Icor or Rush of Icor. I'm not sure how to pronounce it. But that Ryan Miller allegedly left UD, took the mechanism for how the game is played and used that for Lorcana. So it's basically a lawsuit, kind of a trade thefty kind of lawsuit saying, hey, Lorcana is basically Rush of Icor. And you got to the market first and you have destroyed the value of Rush of Icor. So we want basically that back. We're not going to, our product could come out right now and everyone's going to look at us and think we're a Lorcana clone when really we were the first ones out there. So it's been a fun lawsuit to watch because you have Upper Deck, who's mainly known for their sports trading cards. Sure, they've got some entertainment and some TCGs out there, but they're really known for their sports cards. suing a new entrant into the TCG area, and has to do with Disney cards. And there was a lot of worry at first that Upper Deck might shut down or try to shut down the Lorcana cards before they were released. Upper Deck decided not to. This lawsuit's been on a slow track because Upper Deck, and this is like the stuff that only a lawyer would like, but Upper Deck sued Lorcana in state court in California. So the defendants, Ravensburger and Ryan Miller, had the case transferred from state court to federal court in California. So Upper Deck lost their judge. Then they asked, hey, we should actually transfer this case from California to Seattle, because that's where Ryan Miller lives. He doesn't live in California. So this lawsuit should have been brought in Seattle. And I was kind of down on that chance because it's really, if the case goes that way or went that way, you're kind of saying anybody who works abroad, or works remotely, they can only be sued where their house is rather than where their employer is. So I thought it was kind of, silly. But a couple of weeks ago, the California judge transferred the case to Seattle. So it's kind of, you have a holding out there that, I think a lot of companies probably might want to look at, where if you have remote employees and your remote employee, allegedly steals trade secrets and you want to sue that remote employee, you may have to sue them where they are. And since we're kind of in this remote economy where, people could be working from Hawaii or Bangladesh or wherever they are, it's something that, might have this unintended backfire of limiting where people remotely work, especially for California companies. Unfortunately, that's all that's happened in this lawsuit. This lawsuit was filed, I think, in March or April. I mean, it was pretty early in 2023 when it was brought, and we're still at square one. While Ravensburger and Miller did move to dismiss the case, saying that there's no merit to it, the California judge said, you know what? I don't need to make that decision. The Seattle judge, he has to make that decision, so I'm going to punt and let him do it. So the case is, in Seattle right now. It's still at square one. We don't know if it's going to continue, and if it does continue, which will probably be decided in 3 months. We still got time to even see if the case will continue. So it's a fun one to watch. It's frustrating how long it's going to take for that one to begin, but it's interesting because mainly the litigants in the hobby are sports trading card companies. So this at least branches us out to trading card games, and so we get to see a different side of the hobby here.
And these cards are already produced, so Upper Deck really at this point, once they find, for them to win, it would have to be a financial win rather than stopping production of the cards. They're already being made and sold. So this, for them, for a win for Upper Deck would be, hey, Ryan Miller and your company, you owe what, you have to pay this to Upper Deck.
Right. Yeah. And they're still seeking some type of injunction to shut down, which is very different. It's very difficult to get in the first place to shut something down. Maybe they Upper Deck says they have patent applications on file that if those ever issue, if they get a win there, well, then Ravensburger might have to change their rule set if it's found to infringe. There's lots of ifs there. I don't think that'll happen, but there is a chance a long way down the road that, if Upper Deck gets lucky and gets a lot of wins, that Ravensburger may have to do something. I think it's unlikely, though. I think you're exactly right. This is probably a financial. If Upper Deck does win, it'll be financial. It won't be some type of injunctive relief.
And you mentioned that, now the case is in Ryan Miller's backyard, if you will. In sports, there's a home field advantage, right? You play in your home stadium with your home fans. That's in reality, that's probably doesn't translate into a courtroom. Like, a judge is still gonna, there's no hometown judge. Oh, you're from here, I like you. I mean, that or at least to me, it shouldn't be like that. It's just the convenience for, in this case, Ryan Miller.
It's difficult to tell. Sometimes depending on if you're the winning side or the losing side, you think you got hometowned. I mean, there's a couple of courts that I have definitely been hometowned in. Seattle isn't one of them. I'm looking at you, Minneapolis. But the really what you're looking for more so in the danger to upper deck here is the David versus Goliath type situation. If you get a jury here, it'll be a Seattle jury. Ryan Miller is an individual from Seattle. So depending on how the themes of the case go, it could be, hey, Upper Deck's this big company that's picking on their, this little employee from Seattle. To the extent there could be some hometown advantage, it's the jury could look at Ryan Miller, more relate to him than to the California Upper Deck company and, side with him on those, 50-50 close calls. And that's really, to the extent there's hometown advantages, it's where you have the 50-50 shots. Who are you going to side with? The California company that looks really big that might be picking on the individual, or the guy I've actually might see at the supermarket every once in a while.
So they're going to play to the sympathies of the jury, like you said, the David versus Goliath, big bully picking on someone just trying to make a living or do their job and that sort of thing. And that's where the locale might be a factor.
Exactly. And the David versus Goliath is it's a very popular theme in the judicial court system. I mean, it's, any legal movie that you watch basically has a David versus Goliath situation. It is a powerful theme. And that's why, I do plaintiff's work. I tend to represent the Davids in those situations because it is such a powerful theme. I mean, it's America. Everybody likes to see, the individual topple the big Goliath of a company. Everyone loves that. So that's
what do they say? Everyone loves an underdog, right? So
exactly, it's exactly it. So I think it, and then Upper Deck will be like, hey, that's not Miller. That's Ravensburger. They're not a small company either, so they might say David and Goliath. It's not.
Yeah. All right. Probably we're one more case. Your pick, obviously. What other one piques your interest and you're keeping a close eye on?
Another one I like is, Ken Golden had his show on Netflix, The King of Collectibles, and I'm not sure if you watched it. I rather enjoyed it. I thought it was a pretty good show.
I saw bits and pieces. I know a lot of the history of Ken Golden. Not that the show really focuses a ton on that. He's been on this show, so he's an alumnus of this show as well. But I haven't watched. I wouldn't say I've seen bits and pieces. So apparently I think you've seen more of it than I have. But
yeah, you should. It's fun. Next time, it's the holiday season. You get some downtime. It's a quick watch, But he and Netflix and Golden Auctions got sued by an individual who said that the King of Collectibles infringes a copyright he has in his show called The Golden Boys. And apparently, what happened pre-COVID? I think it was pre-COVID. He reached out to Golden Auctions and came up with an idea for a reality show involving Golden Auctions to cover what was going on there. And they put together a sizzle reel where, it was basically, they had a couple instances. They talked to some people. They showed some memorabilia. And COVID happened. People fell out of touch with people. And for whatever reason, we don't know what it is. And that's what the lawsuit will be about, probably. Golden decided not to go forward with this person with the show, and instead decided to make a reality show with Netflix. So it's an interesting case because the copyrights are a little narrower than most people think they are. A copyright in a TV show really covers that TV show itself. It doesn't necessarily cover the idea, and copyrights don't cover ideas. And this lawsuit seems to be overreaching. It seems to say that the plaintiff in this case thinks that he owns any reality TV show based off of Ken Golden and Golden Auctions and what they do. And that's, I think it's an overreach because, first of all, as much as I like the show, it was kind of, it followed the general format for reality based TV shows. It was kind of Pawn Starry, a little bit more focused on, the items and, getting them in and bringing stuff up. But it was very similar to other reality shows that were out there. And copyright doesn't cover that. It covers specific instances. So that's a case that's fun to watch because Ken Golden and Golden Auctions are getting a second season at Netflix. This guy's alleging that second season, even though he's not seen it, infringes his copyrights also. And we'll see where it goes right now. It's, again, like everything it seems like that we talked about today, it's in the motion to dismiss phase. So Golden Auctions said that, and Netflix said that the case has no basis, basically saying what I said, that it's an idea. You can't copyright an idea. Nobody owns any reality show based off of Golden Auctions. And we'll see where it goes. But it's a fun one again to watch because that Netflix show brought, more eyeballs onto the hobby. It got renewed for a second season. And, unfortunately, when you get more eyeballs, potentially you get more potential plaintiffs and lawsuits that come out of the woodwork.
Now, again, I'm not in the legal field, but the first thing that struck me hearing you explain what was all the details involved in this case, like even though this might, he did a sizzle reel, which in a sense is like a trailer, unless you have like a signed contract from Golden or Golden's auction that we're going to go in production with you to make this show. Like this one seems like an easy. I could be wrong. You're gonna either correct me or like this one would be to me easy to dismiss to Netflix and Golden side. Say, hey, there's no contract. There's no signed agreements that we were going to shoot this show with this gentleman. We have that here at Netflix. This one seems pretty black and white, cut and dry. And is there more to it than that, Paul?
No, I think you're right. I think it is cut and dry. There isn't an allegation of, like you said, that we have a contract. Like if the plaintiff had a contract with Ken Golden and Golden Auctions that said, I will be the only person within this time frame that can make a reality show of here, and there's money exchanged to show that, then it would be a different case. But this case solely is focused on copyright. It's focused on intellectual property, and that's not what it's there for. So I think it will be a open and shut case. However, looking at the Ravensburger case, I thought that motion to transfer to go to Seattle was open and shut, and there's no way that would have been granted. So part of the fun in litigation is the judge is still a person, and they may seize on different things. And while I think there's a 90% chance that this case is dismissed, there's always that you just never know. Because, the judge might look at it again. It's another potential David and Goliath situation. If you look at it, it's ultimately an individual who decided or who wanted to make this and had some, help in trying to make this product. And then big old Netflix comes in and takes it and runs somewhere else. So the judge might say, hey, I'm kind of like the little guy here. So we'll let this case at least continue for a little bit and see where it goes. You just never know in the legal field.
And a win for the little guy in this case, if he was to win, would again have to be financial, right? Golden's not going to stop shooting with Netflix if he was to win and say, okay, we'll do that show. So the only thing they'll get or he'll get would have to be a financial victory. They're not going to get the show as originally or what he thought was originally planned.
Right. And you never, let's hypothetically say the case was stronger and this guy might actually have a chance of winning. He could actually potentially negotiate okay, you can keep doing the show, but I get a cut of the show. Or it could also be where, well, I want the show taken down. If he does win the case, one of the options, especially I love copyright cases and trademark cases, because part of what you ask for in your relief section is that the infringing IP be destroyed. That's the words in there, destroy it. So there is it's very difficult. I don't think it would happen here, but if he had a stronger case and won, he could seek injunctive relief to have Netflix hit the delete button. It won't happen. I can almost guarantee that won't happen, but that is a possibility that's out there if it was a stronger case.
In these cases, from a lawyer perspective, Paul, the gentleman, are there lawyers that will say, or maybe this is exactly what happened, like, you're a long shot to win this. I'm not taking this case. I don't have the time. You've got like a 10 or 20% chance, if that, of winning that. Does he have to like sort of lawyer shop to find someone that says, all right, I'm going to take up this, this banner and run with you? How does that go?
You're exactly right, because as a plaintiff's attorney, I'm really picky in the cases that I bring. I mean, I've rejected 99% of the cases that have come to me, because when you're a plaintiff's attorney, you're putting up all the money, you're putting up all the capital, and you only get paid if you win. So if you file a case and you put up all the money and it's a loser, that's not a good business, way to run a business. You're going to go bankrupt at some point. Here, and it was something that I pointed out, the attorneys that brought this case, while they're business attorneys, they've got a lot of business B2B type litigation, business to business type litigation. I don't think they've ever brought a copyright action before. So I think this is one of those ones where they're unfortunately getting an education in copyright law. That's probably why they took the case. But sometimes you will take a case that might have only a 50-50 chance of winning if there's a lot of money involved in it. So that could be something here. Maybe they looked at the case and they said, okay, I think we probably only have a 30% chance of winning, but if we win, it's $1 billion. In that instance, it might be worth, $100,000 bet to see if we can actually win $1 billion. Maybe there was some type of calculus like that. I think it's probably more. You have people who are not familiar with copyright bringing a lawsuit. They think it's stronger than it is. Unfortunately, like I said, they're getting a copyright, $100,000 copyright lesson right now.
One last question pertaining just on the tax side of thing. You mentioned yourself, like, you take a case that you feel like is a strong one, because if you don't win, you don't make any money. You're not going to put. Is it at least, if that happens, worst case scenario, you don't win a case, you don't get paid, is it at least a tax write off for your business? How does that work?
So that's one of those things. Luckily, I don't get to do the finance side very much when it comes to this. I'm the guy that shows up to court, and we have somebody above me who handles all that stuff. But yes, it is a business expense. But I'm pretty sure when it comes to like patent plaintiff expenses that you put into a case, I don't think it's an immediate business deduction. I think you have to amortize it over a few years. So I think it counts more as, whatever that is, it counts more as property than as an immediate business expense. So yes, you can deduct it, but it's not all in 1 year.
Better to win the case and worry about tax write-offs.
Right. No, it's so much better to not have to go to the managing partners and say, okay, we're going to have to write off $200,000 here. It's don't worry, we can take it over 5 years. It's better to win.
Well, Paul, thanks for coming back on, sharing some of these cases, covered a little more ground. Again, I'll say it again, love to have you back, maybe in a few more months, and kind of make this, as long as you do it, sort of almost a regular segment, kind of maybe some new cases that pop up by then, or follow-ups to stuff we discussed. Before I let you go, to how many, I know you said this last time, to your knowledge, how many hobby-related cases are on the dockets as we speak today here in late December, early January?
And this is with the disclosure that there are some cases that are out there that I probably don't know about, because I can look at every federal case, every federal court, and see what's out there. I can look at about 30 state court systems and see what's out there, but there's some that are just unfriendly. So that, with that long intro, there's about 40 cases that are out there that are pending that can be watched that we know about. 2023 was a busy year. We got a lot of new lawsuits. But some of them are resolving. The Panini WWE case that looks to have resolved itself. The Bang Bros Cards case looks to resolve itself. So I'm hoping 2024 we'll see some of the 2023 actions. We'll get past the motion to dismiss stage, and hopefully we'll get a bunch more.
And you'll be in your glory, as they say. You love it.
No.
I mean, this is
It's one of those things where it's so silly that I mean, like sometimes you'll get a new filing because nobody in the legal area files their stuff until like 3 in the afternoon, 5 in the afternoon. So, but there have been multiple times this year where it's Friday at 5 o'clock. And I go to my, everyone else is going out, going to the movies, going to the bars, getting a drink. I'm sitting at my computer. I'm hitting refresh to try and see if anything pops up here because I want to find out what happened here. So
well, listen, you love it, you're passionate about it, nothing wrong with that. This is your, in a sense, livelihood. While you might not be directly involved, you're an attorney yourself, so you have at least an interest on that level. And listen, you keep us all abridged and informed. We don't speak legalese, and the way you do a great job. You don't need me to tell you this. You do a great job of breaking it down, sort of in layman's terms, so someone who didn't go to law school like myself can understand what's in play, how this works, maybe who's the favorite, who's the underdog, at least on paper. And I always enjoy picking your brain, so to speak, and seeing how this can affect the hobby. Love to have you again back on. We'll kind of retouch base, but as always, I give the guests sort of the final word where people can find your content and your the stuff that you post pertaining to the hobby and the cases involved.
no, thanks, and I really appreciate that. Thank you. And if anybody wants to find me, I'm on Twitter at Paul_Lesko. I'm almost on there every day talking because there's almost something happening just about every day. It might be minor, but there's something fun to talk about.
All right, Paul. Well, listen, this was your second time on. I hope it's not the last time on. We'll and if like you said, with 40 cases that you even those are the ones you know about. I think you'll have plenty of material when we can have you back, and maybe by what time you come back, we even have some new ones make on the horizon as well.
Perfect. We'll do that definitely.
All right. Thanks, Paul.
Okay. Thank you.